Thank you to these companies and organizations that make the Before I Die New Mexico Festival possible. A good goodbye. Gail Rubin puts the fun in funeral planning. Compassion and choices, improving care, expanding options, and empowering everyone to chart their end-of-life journey. Daniel's Family Funerals and Cremations, Fairview Memorial Park, Gabaldon Mortuary, Sandia Memory Gardens, and Vista Verde Memorial Park, all in the Albuquerque area. Estate Pros, offering professional dispersal of personal possessions due to a move, illness, or death. The Final Exit Network, educating about and defending the right to choose at end of life. French Funerals and Cremations and Sunset Memorial Park in Albuquerque. Gathering Us, providing in-person and virtual memorial services and online memorial pages. Keeper, providing hybrid and virtual memorial services and keeping memories alive with online tributes to preserve, celebrate, and share life legacies. Morris Hall, estate planning attorneys in New Mexico and Arizona. Remembering a Life, your guide to honoring a life well lived, from planning a tribute to mourning a loved one. And Retirement Extender, investment management services with a personalized strategy recommendation based on your needs and objectives.
Hey, thank you very much. Welcome back live in Albuquerque and out there on Zoom land. We're starting our next session. Well, as you heard Melissa say, everyone has an estate, learning what legal documents you need. Our speaker is Lisa Cosper. She is an estate planning attorney with Morris Hall. She worked as a paralegal with Morris Hall since 2014 in both estate planning and estate administration departments while she was attending law school. So she really knows her stuff when it comes to how trust documents are established and administered. So please welcome Lisa Cosper.
Hello, thank you everyone for joining us today. So just a little bit about Morris Hall. We are an estate planning law firm. We have 8 attorneys and 13 offices located throughout Arizona and New Mexico. One of the things that makes Morris Hall unique is that we only practice in estate planning. So we don't dabble in criminal law, we don't do family law, we only do estate planning, and this allows us to focus our practice and be updated on the most current information when it comes to estate planning. That way we can provide our clients the best services possible. If we did a little bit of family law and criminal law and all the other different types of law, we wouldn't be able to be experts in our field. So just a little bit about me. This is what I call the boring slide. Nobody really cares where I went to school or where, how long I've been with the firm. I went to school in Arizona and I graduated from Arizona, got my license there, and in 2019 I moved to New Mexico, and I'm also licensed here in New Mexico. But this is the fun slide. This is all about me. So I live in the East Mountains with my 5 rescue dogs and my husband. I have a very blended family. My parents were divorced when I was really little, so I've got the privilege to have an expanded family with my stepmom and a special needs brother. And then on my mom's side, I have 3 siblings that I'm very, very close with. We all grew up together, so I get the privilege of having a blended family. What this means is that it gives me a little bit of a unique outlook on estate planning, because not every estate plan is the same. Everybody's got different family dynamics, everybody's got different goals and objectives. And the reason I share this with you is just to give you a little bit more personal information about me and why I do things the way that I do them. What we're gonna cover today is we're gonna go over what an estate plan is, what the difference is between a will and a trust, healthcare documents, financial powers of attorney, and what considerations you should be thinking of when you're picking different agents to serve in these capacities. First thing we need to discuss is what is an estate. So An estate is everything you own. It's your cash and your other bank accounts. It's your property. It's your retirement accounts, your life insurance, everything you own. So an estate is most commonly misconstrued as real property only, but your estate is everything you own. So who here has stuff? And I'm sure Karen just went through and talked about how to organize and downsize your stuff. So since we all have stuff, we need to plan on what to do with that stuff when we're no longer here. And what we do with that stuff depends on what you have and what you want to accomplish with that stuff when you're no longer here. A couple of different planning options. One option is you can spend it all. So I don't know how many of you know exactly when you're gonna die and exactly what you're gonna have at that time when you die, but spending it all probably isn't the best planning option, because you can either spend it all before you die and then you don't have enough resources left to continue living, or you can die prematurely before you plan on dying, and then you still have stuff that needs to be dealt with afterwards. So hindsight 2020, probably not the best planning option, but some people do plan on spending it all. Another planning option is what's called joint tenancy. And this is when 2 or more people own assets together. This is really common between married individuals. Husband and wife own bank accounts, vehicles, real property together. And as long as the accounts are titled joint tenancy with right of survivorship, then it passes to the surviving joint owner. A lot of times we see when individuals will add other people onto these accounts. Sometimes it's with children, sometimes it's with nieces, nephews, caretakers, people who are helping them manage their affairs. While this is convenient because it allows your agent to be able to have access to your accounts during your lifetime to help you maybe manage your expenses and pay your bills, this isn't necessarily a good planning option, because by adding somebody else onto your accounts, you've given them an undivided ownership interest in your account. So hypothetically speaking, if you have 3 children and the one who lives here closest to you, you put them on your bank account. Say you've got $10,000 in your bank account to pay for your expenses and other things. When you pass away, that whole account goes to the child whose name you've put on that account. If they decide to share it with their siblings, because that's ultimately what your intent is, it's your account, you want it to be split, they're not legally obligated to. That is their account. And if they do share it, there may possibly be gift tax implications with that. The biggest thing we see is when there's real property. Real property is a lot more higher dollar value than most bank accounts that people use for everyday checking and convenience purposes. So with real estate, a lot of the times what we see is that mom or dad will put a child's name on the deed so that they can avoid probate. Well, this creates a whole slew of other unintended consequences when they pass away, because now the child whose name is on the deed inherits a lower cost basis, so they have to pay higher capital gains taxes. If and when that property is sold, they're not legally obligated to share those proceeds with the other people that you may have intended, because they're the sole owner of that property now. And when they do, they have gift tax implications. So while it's convenient and the intent is there, it creates a lot of unintended consequences. Dying intestate. This means not having any plan at all. How many people in this room like to be told what to do? But unfortunately, we see this a lot. We see a lot of people who don't plan for their estate. And when you don't plan, currently the people in this room, if you guys are New Mexico residents, New Mexico will tell you what happens to your stuff and who gets what. This is called dying intestate. Basically, the state will say, who is your next of kin? This is the person who's going to be your personal representative, and will tell you who to distribute your estate assets to. This may work in certain circumstances. You may want your next of kin to be the person who's going to be in charge, and you may want that person to receive everything, but you may not. So for example, let's say hypothetically you have 3 children and one is just rotten. They never came to see you, they never helped with anything. Your other 2 children were always there helping with the finances, making sure everything was taken care of, and you want them to receive the benefit because they're the ones who were there helping out. Well, if you die intestate and you have 3 children and you don't put a plan together, all 3 children share responsibilities, which can cause a clog in the court system if you have to get 3 signatures on every single document that gets filed with the court. And then they share the proceeds equally, which may not have been your intent. So sometimes intestate does work, other times it does not. It's just understanding what your options are and what you want to accomplish. And then we're going to discuss wills and trusts in a little bit more detail. What is the difference between a will and a trust? Well, wills and trusts are written legal documents that say what you want to have happen to your estate if and when you become incapacitated or you pass away. These are written instructions for what to do. Main difference between a will and a trust, however, is that a will goes through probate, whereas a trust avoids probate. You can think of a trust kind of like a bucket. It's a legal document that you create that holds all of your stuff. Now, because your trust owns your assets, your house, your bank accounts, your everything that you own, when you pass away, your trust document privately determines what's going to happen with that, who's going to be in charge and who gets what and under what circumstances. A will is a written document that provides instructions to a probate judge and tells the judge who you want to be in charge and who you want to receive your stuff. Since this is to probate, the person you've nominated inside of your will, most commonly referred to as either a personal representative or an executor, this person needs to be appointed by a court. And whether or not a trust or a will is an appropriate estate planning document depends on your goals. We talked about at the beginning of the presentation what stuff you have and what you want to have happen with your stuff. Well, all of that is unique. Some people don't have an issue with probate. The risks that are involved with probate are very minimal depending on the type of stuff they have and who they want to receive what. Other individuals want a trust because it has more asset protection or more privacy involved. For example, if we have a blended family like my own, when one person passes away, typically most spouses want to provide for the other spouse, and then when they're both gone, to provide for the children. My parents' plan is a little bit different than that. My dad primarily wants to provide for our special needs half-brother. And so my stepmom is excluded from a majority of their estate plan, but they've agreed to this. This is something that they've talked about. And because of the nuances involved in Texas law with distributing an estate to, right now my brother's a minor, for minor children, they have opted for a trust. This is something that's unique to my dad and my stepmom's plan. Not every plan is the same. Every plan is a little bit unique. And the reason why it's unique is because you guys are all unique. You guys have different stuff, different stories, different goals, objectives. And that's why your plan needs to match what you guys want to do. You shouldn't just have a one-size-fits-all bucket because it's not going to work. Some other considerations to think about when you're drafting your estate plan are what's important to you. Are you worried about nursing home care costs if something should happen to either you or your spouse? What if your spouse gets remarried after you pass away? Is that a concern that you have? Do you have concerns that maybe one of your children may get divorced or is currently going through a divorce? What about your loved ones? Do they have money troubles? Have they previously been divorced? Are they spendthrifts? Are they not good with money? Have they filed bankruptcy? Do they work in a profession that's highly litigious, that people are trying to sue them all the time? What about taxes and reducing tax implications? These are not the same concerns for every single person. Some people may have higher priority concerns, other individuals may not. For example, and I like to talk about my family a lot, so I'll tell you a story about my crazy Aunt Molly. She is 4 times divorced, and she is the only sibling or only sister that my dad has. The rest of his brothers, he's one of 5, are all boys. They've either only been married once or are not married. Crazy Aunt Molly's been married a few times, and she's still looking, so she keeps trying to get married and keeps getting divorced. And unfortunately, when she was going through her latest divorce, it was right after my grandfather has passed away. So we had to do a lot of things to try to help mitigate and go through court to say that her inheritance from my grandfather was not a marital asset. She lived in a community property state, and her rotten husband was trying to take part of my most recently deceased grandfather's assets that he had left to her. This is not the case for everybody. Not everybody has a crazy Aunt Molly, but somebody may know somebody with a crazy Aunt Molly. So that's why these things are a good idea to think about. Not everybody's going to have the same issues. These are just very broad ideas to get you thinking about what may be important in your estate and your issues. What is a power of attorney? These are called ancillary documents that supplement your estate plan. So most commonly, most people have either a will or a trust if they've put some sort of estate plan together. This is your overarching document that says what happens when you pass away. Your ancillary documents, your healthcare and your financial power of attorney, these support your final document. So in the event you become incapacitated or are unable to handle your affairs, your financial power of attorney allows your agents to make financial decisions for you. This includes maybe writing checks out of your bank account, talking to your insurance company, paying credit card bills, utilities, mortgages, and handling things that are in your individual name. There's also a healthcare power of attorney, works very similarly, but it's for your healthcare documents. So if you're unable to communicate, this allows your healthcare agent to talk to the doctors and other medical professionals on your behalf. Without these documents, if you do not have proper planning in place, in New Mexico, it's called a conservatorship and a guardianship. If you do not have proper estate planning documents and there aren't authorized people to make decisions for you, your agents have to go to court to be appointed as the conservator. So this is over your well-being, and guardian. So you got the conservator over your well-being for your financial affairs, and then a guardian over your personal affairs. I know many of you have probably heard of the Albuquerque Journal story about who guards the guardians, and I know they wrote a recent report about some of the things that they uncovered during that investigation. I don't think any of us want our estate to be subject to something like that, where we've got other individuals who we probably wouldn't have appointed and taking advantage of us, taking advantage of our hard-earned worked assets to essentially benefit themselves, not you. So having a proper estate plan in place is very important to make sure that your wishes are honored and that you're protected. Doing all of this protects you and your loved ones. Couple of things that I want to stress about the importance of powers of attorney. They are only effective while you are alive. They are no longer effective upon death. So these do not overwrite your will. They're not going to allow your agent that you've nominated to close your bank accounts or sell your property once you're gone. So it's very important to have a complete estate plan with all of your documents. There is a list of priority for appointment of your agents. This is a presumption, not an automatic designation. So while it is presumed that your spouse is your first primary agent, that is not automatic. Unfortunately, we've had several instances. It's usually involving second marriages where there's not common last names, but where a spouse is hospitalized and the doctor will not take the direction of the surviving spouse because he could not verify that that person was married to the person who was currently undergoing treatment. Took a lot of documents, going through and trying to find the marriage certificate, contacting the county because they couldn't get into the safe deposit box over the weekend, and you don't want to have to deal with this when your loved one is trying to go through surgery or trying to get treatment options. It would be much easier just to have those documents in place. A lot of the times, if you are unmarried, your children are your next then living relatives, and they're the ones who are designated in order of priority for agent. If you have more than one child, they all have equal opportunity to say what they would like to have happen. And I don't know about you guys, but me and my siblings don't always agree on everything. We try, but we don't always. Sometimes we have a little bit different views. And if my parents don't have written documents in place, what me and my sister and my brother on one side would say is best for my dad, we may not agree. On my mom's side, me and my 3 other siblings may not agree what's best for my mom. And what happens if there's a disagreement, there's no written documentation, you've got more than one person with priority to say what happens, the hospitals don't want to get sued. They don't want to know, or they don't want to risk that they're making a decision and they shouldn't have taken that authority, so it gets sent over to their arbitration and their litigation, and all while your loved one is sitting there needing treatment. It's much easier to avoid these conflicts up front and having written direction. So what are some of the considerations you should think of when you're appointing your agents? So under a trust, you have a trustee. This is the person who will handle your affairs upon your death or your incapacity. Under a will, you have a personal representative or an executor. You also have healthcare and financial powers of attorney agents. And all these people don't have to be the same people. They can be different people, but we highly recommend having a conversation about what roles these individuals may or may not be serving in. So for example, if you have a trust, we typically recommend that the trustee and the power of attorney agent for financial matters be the same person, because a lot of their duties overlap. But that's not always necessarily the case. It depends on your individual goals and objectives. Your healthcare agent also does not have to be the same as your financial agent. They may be, but there may be a reason to nominate somebody else. So some of the factors to consider are age of the agent. A lot of times we get individuals who are coming in and they're not planning on dying. So they nominate maybe friends or other relatives who are of the similar age as them. Well, that's great for right now, but we don't want to use these plans for many, many, many years. What happens if those individuals are the same age as you and they're also of diminished capacity at the time that they're asked upon to act on your behalf? Their experience, maybe we know people who are in the financial field and would be better suited to make financial decisions, or maybe we know people in the medical field who are able to make those decisions. And ultimately your relationship with these people. At the end of the day, are the people that you nominate going to respect your wishes and what you want? Before I was married, I had my parents as my agents. I had my dad listed for everything. Mostly because he was more savvy when it came to financial matters. And even though I have a closer relationship with my mom on a personal level, I knew that in the event that she had to terminate life support, she wouldn't do it. She is very opposed against it. She thinks she's gonna live forever and ever and ever and wants to be plugged up for all eternity. But that's her personal choice. And I knew if she had to make that for me, it would be a very, very hard and emotional decision. And in all honesty, I don't think she could have done it. So it's not that I loved my dad more than I loved my mom. I just knew my relationship with my mom and I knew she wouldn't be able to do that. You guys know your people that you want serving in these capacities. You're gonna know whether or not they're gonna be able to serve in those respective positions. And great news is, while you're alive and well and you've got capacity, you can always change it. They're amendable, changeable, revocable documents that if something happens in your life, you can change it. We highly encourage 3 to 5 year reviews of your documents. We don't want you to just draft these and then put them on the shelf and forget about them forever and ever and ever. What if things change? What if your relationships with the people that you've nominated change? What if your stuff changes? What if you no longer live in the state that you drafted your documents in? These are always things to keep in mind and keep them up to date. They should just never be a one and done. How do you accomplish peace of mind? Well, when it comes to estate planning, peace of mind is accomplished by having a full and complete estate plan. You don't want holes in your plan, because the more holes you have, the more chance that there's going to be errors or hiccups or issues later on down the road. So you should have a complete either will or trust. If you have a trust, we also include what's called a pour-over will. This is your safety net. We don't want to use it, but it's here just in case. This acts in the event that there's something you forgot about that you didn't put into your trust, or maybe you acquired after your trust that just didn't make it in. Your pour-over will pours it back into your trust, so that way it can be distributed in accordance with the terms of your trust. Financial power of attorney, your living will, these are your end-of-life decisions. Healthcare power of attorney, your HIPAA, assignment of personal property. This causes the biggest issue when it comes to litigation is personal property. Most people are not going to spend $10,000 to collect a $9,000 bank account. They're in the hole $1,000. It doesn't make sense financially. But when it comes to sentimental items that are emotional, that people are attached to, logic goes out the window. It is very, very important, and I would highly encourage having these conversations during your lifetime about what the importance of the item is to you. Maybe you don't know that that item is important to your loved ones who you've left behind. Me and my sister are the only granddaughters on my Grammy's side. And throughout the years, we used to go and visit her every Thanksgiving, every spring break, and every summer vacation. And we'd bake cookies, we'd bake pies, we'd make jam. And so her recipe book is very fond to us. And over the years, she sent us recipe cards. She won't tell us which one's the original, even though my sister and I know which one is. But she shared those with us. And these are memories that we've created with my Grammy, and my Grammy knows is important to us. One of the things that we didn't know was important to my Grammy is that she has this really, really ugly green pot in the front of her door. Had no idea where it came from, didn't know its value, just thought it was something my Grammy had probably gotten from like Pottery Barn or TJ Maxx. She likes to go shopping, and her favorite color is green. Well, after my grandfather died, she told us that this is actually an old family, I don't know if you want to call it an heirloom, but it's an old family possession that she got from her grandmother, who got from her grandmother, and it came from Germany. We honestly probably would have sold it on an estate sale, and my grandma would be rolling over in her grave, yelling at us from beyond that we let this happen. But we didn't know. She didn't share that story with us until much later when it came about, when we were asking her about it. I can guarantee you there's things that maybe your loved ones don't know that you have that's important, and maybe there's things that you have that your loved ones treasure that you don't know is important. My dad had this painting done, and I didn't even know it was a painting. I thought it was just a printed picture. When we were younger, he had this cartoon strip in our bathroom, and it's pilots sitting in a cockpit. My dad's been a pilot since forever. He's joined the service, and then after the service, he flies privately for UPS, and he will be in an airplane forever and ever and ever. The pilots inside of the cockpit are shaking the plane around saying, "Dear passengers, we've experienced some turbulence. Please fasten your seatbelts," as they continue to shake the plane, and they laugh and they think it's very funny. Well, I just remember this from when my parents were married, and it was downstairs in our guest bathroom. My dad was going to throw it out. I had no idea he didn't want it or anything else. So I had mentioned it to him. "Hey, whatever happened to that painting that you had?" As he was moving his stuff from Texas to Alaska. He said, "Oh, I was going to give it away. I didn't need it anymore." I said, "Can I have it?" He's like, "Yeah, I had no idea you even wanted it." Then he told me he had it painted while he was in Korea when he met my mom. I didn't know. And I guarantee there's things that your loved ones don't know about, things that they treasure, or you don't know about things that they treasure. So if anything, your personal property, if you can avoid any kind of contentions, this is where it's going to really stir the pot. You can have a written plan down for who you want to be in control, where you want your stuff to go. You can have a flawless estate plan, but sharing those memories during your lifetime, I think, is more invaluable than the plan itself. Contingency checklist. What can you do to make things a little bit easier for those that you've left behind? Clean out your files and drawers. I know Karen just gave probably really, really good examples on what to do, how to downsize. This is so important. I can't tell you how many family members have brought in suitcases and suitcases and suitcases full of stuff that they don't know what is still current, what still exists, what went where, and we have to spend time and money sorting through all of this, figuring out where all these assets are, where they went. So just keep the most recent information. Tax returns you only need to keep for approximately 7 years. You do not need to keep 30 years worth of tax returns and stapled receipts in shoe boxes for the last 20 years like my grandfather did underneath the bed in the spare bedroom. See an attorney about your estate plan. Even if the attorney says everything's good, it's always better to have that second opinion, because you're looking at it from a personal side of what you want. We're looking at it from a legal side. Do you have all your ducks in a row? Do you have all your T's crossed? We offer complimentary reviews at Morris Hall, and a lot of the times, most people who do come in who have a well-drafted estate plan, most of the time we just tell them what they need to do to tighten it up. Sometimes we have to do a complete overhaul, but that just depends on what your goals and your objectives are, how your plan was drafted, and how your personal issues may or may not have changed over the years. Talk to your loved ones about your estate plan. Let them know you have one. Don't let them guess whether or not you did or you did not have a will or a trust. Let them know where to find it in the event of an emergency. talk to them about your expectations. So a lot of the times there's a lot of misconceptions after a loved one is gone, and it creates a lot of tension and issues. We don't know that this is going to happen, and we can't ask you after you're gone. So if you've nominated one child or one person to be your executor, your personal representative of your estate, sometimes this can cause hurt feelings with other people because they think, oh, well, why wasn't I picked? Well, I like to tell them, well, now you get the easy job of being the beneficiary. You don't have to do all the work, but sometimes that hurts. You know, they think maybe I was the responsible one, or I was the one who was supposed to be in charge. If you set that expectation up front and you have that conversation, if you're able to, it makes things easier when you're gone because we can't ask you anymore. If for some reason you can't have that conversation, sometimes there's contentions between family members, and sometimes that doesn't always go over well. I highly encourage writing a letter. It helps explain things when you're gone, helps alleviate some of those questions and those concerns. Make a list of your personal items that you want going to certain individuals, and if those items are of value. We had an estate where personal representative thought Dad just collected a lot of junk, and to most people it would have looked like a lot of junk. Fortunately, one of the heirs was kind of into the same collectible items and realized, hey, you can't just drop this all off at Goodwill. This is actually some valuable items. We see this a lot with artwork, rugs, pottery, because people value different things. Just because something's collectible doesn't always mean it's valuable, and just because it's valuable doesn't always mean it's collectible. Having that conversation and letting them know, just like my Grammy's ugly green pot that we will probably now keep. If you don't know what the value is, or you don't know the significance or the importance, or your heirs or your loved ones don't, it'll probably end up at either an estate sale or Goodwill or donated, or somewhere you may not have wanted it to go. So having those lists of personal items to help mitigate any potential issues, and then writing a letter to your loved ones. This is very important. We can't ask you things after you're gone. We want something to hold on to, remember you by, and that letter is very, very, very personal. When my grandfather passed away, he nominated my dad and one of my uncles as the co-personal representatives of his estate. And the reason he did this is my dad is very direct, and sometimes that rubs people the wrong way, and he's just very short. You ask him a question, hey Dad, how are you doing? Good. That's the only answer you get. And it's not because he's rude or he's mean, he's very short, but some people take it a little offensively. And my other uncle is very patient. He's a teacher, very calm, and will explain things till no end. And the reason he did it, and my grandpa put this in his letter, was because he knew my crazy Aunt Molly was going to have lots of questions, and he knew that that would probably cause some friction between my dad and my Aunt Molly, and he put my uncle in there as a buffer because he was the mediator to the whole family. He could get anybody to get along. And that letter went a long way to explain things to my Aunt Molly that none of us, even until we were blue in the face, could have explained it in a better way. So this is my contact information. I also have some goodie bags in the back, and I think my bio with the contact information as well, if anybody's interested. We offer complimentary appointments at Morris Hall, so if you guys are interested in just a free review just to make sure your plan is in order, or to put a plan in place if you don't have one, please contact us. We're happy to assist you. I know there are several people who are also on our Zoom attendees. We are licensed in Arizona and New Mexico only. If you are in another state or a jurisdiction, unfortunately, we are not licensed to practice in other jurisdictions, but we can get you in contact with one of our attorneys that we work with throughout all 50 states who can do a review for you or to answer any state-specific questions that are not Arizona or New Mexico. Thank you.
Surely you must have questions.
I have a comment. Having lived through a hot mess of my stepfather dying intestate and my mother passing semi-intestate, that being the one piece of real property that she had was not put in her will before she was able to pass, I can say thank you so much for laying all of this out, because I feel like it's something that we all need, and the more that we can get together, it just makes life, I mean, it's already intense enough when you have everything together, but yeah, so just thank you so much for being here and your presentation.
Thank you.
Can you summarize what
Yeah,
you just said?
so I don't know for those of you on Zoom who caught all of that, but just a quick summary of the comment. And I'm sorry, what was your name?
My name is Chris.
Chris from Chris. Thank you so much for your lovely comment. Talking about estate planning ahead of time just helps alleviate and mitigate issues. If you can have even a well-documented plan, put everything in place, but you know, like you mentioned, it's so chaotic, and just not having a plan in place makes it that much more difficult for our loved ones when we're not there.
We have 2 questions from the chat.
Okay.
How do you ask about your family's estate plan without sounding like a money grubber?
How do you ask about your estate plan without sounding like a money grubber? Well, that's kind of a difficult plan. It just depends on your family and your relationship with your family. So fortunately, I'm an estate planning attorney, so I just tell my family, you're going to tell me what you're going to do. And most of the time they listen to me. But, you know, not all of us are attorneys or estate planners, so sometimes that's a hard conversation to have. I would say you know your family better than I know your family, so what common interests do you guys have? How do you guys have conversations? If, let's say, hypothetically, mom or dad is coming up for a, let's say, routine visit with their healthcare provider, and they ask you to drive them. That's a good interjection to ask them, do you have healthcare documents in place? Do we need to talk to your doctor about getting something implemented? Or if you have, let's say, mom or dad or your loved one is starting to have difficulty writing checks, ask them, do you have a power of attorney? What's going to happen if you can't do this? Talk about sentimental items, you know, over Christmas or holidays. Hey mom, where did you get that painting? You know, does anybody know, you know, where do you want that to go? Everybody's going to have something that's a little bit different for their family and their circumstances. And I know it's a little taboo to talk about money and death and dying, but that's the purpose of these conversations, is to make it easier to have those conversations. Even though it may feel uncomfortable to ask your loved one what's going to happen to their affairs after they're gone, I guarantee that's an easier conversation than fighting it out with the ones who are left behind when that plan isn't put into place.
And the other question, and then we'll take questions in the room, what makes a gift taxable?
There's a lot of things that can make a gift taxable. The dollar amount of the gift you're giving, the type of asset you're giving, how it's being given. I know a lot of people don't like the "it depends" answer, but it really depends on the asset. So the most generic answer is if a gift is over $15,000 per person. So hypothetically speaking, if my husband and I gave a $30,000 gift, we would be under the exemption because I can give 15, he can give 15. But if that asset has any trapped taxes for basis or capital gains, then that's where you may still face a tax issue.
I'm interested in transfer upon death. Any comments you have about that, whether it be car or house or other solid property?
Yeah, so the question is what happens and how to facilitate a transfer on death. Transfer on death for vehicle, New Mexico doesn't currently have a transfer on death forms. I know some other states are very state specific and do have transfer on death applications that you file with the motor vehicle department. Arizona is one of those states that has a transfer on death form for the vehicle. Most vehicles fall under the exemption limit for probate. So as long as the total value of your estate assets in New Mexico are less than $50,000 that you're transferring, so hypothetically speaking, let's say you have a trust, everything's in your trust except your vehicle. Your vehicle is probably going to be under $50,000, so it's going to bypass that process with a small estate affidavit, and that's how most people transfer the vehicle. If you want that vehicle to go to a specific person, you're going to write that down in a personal property list. And if you have either a trust or a will, most trusts and will allow you to keep a separate handwritten document for personal property designations, and that includes the vehicle. So most of the time in most estate plans, vehicles are transferred via that small estate exemption. For real property, you have to record a transfer on death deed. and this has to be recorded before your passing or else it is not valid. If you transfer an asset via transfer on death deed, what happens is that upon your passing, your death certificate gets recorded and then the property gets transferred to the individual that you've left it to. Potential issues with transfer on death deeds would be if you wanted to leave it to more than one person. Now there's two joint owners who have the property, and if one wants to sell but the other one doesn't, that's where it can get a little bit sticky.
But if it's just one person, it would be pretty straightforward.
Mm-hmm. So long as they don't have any other potential issues, and these are just, you know, potential risks. They're not for everybody, but hypothetically, if you were leaving your house to my crazy Aunt Molly and she's got all sorts of debts and loans and obligations, well, now they can put a lien on that property because now she has an asset that a collector can come and try to take. So just depending on your situation, simple transfers.
Are there tax implications with transfer on death deed?
There's not an inheritance tax. So the state of New Mexico does not have a state estate tax. The current federal exemption for estate taxes is $11.5 million. That's subject to change. They're bringing that back down between $3 and $5 million. They're still talking about it. So we'll know more before the end of the year what that gets ultimately decided on. Potential tax issues with the transfer on death deed is going to relate more closely to either capital gains taxes. Because if you purchased a piece of property, let's say for $50,000, by the time you pass away, it's worth $150,000. Valuing that asset as of the transfer can sometimes be difficult, which leads to an increased risk of capital gains taxes, but not necessarily that there will always be taxes as a result of that. Okay. Yes.
I have a situation where most of my family is gone, and I moved away from other family members, but I'm just not too comfortable with assigning it. So I can hire an attorney to be my, what do you call it, the personal representative and trustee. Is that how, so you provide services like that, correct?
Correct. So the question is if you either don't have somebody or all of your family members are distant relatives that you're not comfortable nominating, there are options available. So you can either hire an attorney, you can hire CPAs. They're very often appointed as personal representatives or financial powers of attorney agents. There's also public and private fiduciary companies that serve in these capacities for health and financial decision makers. So it just depends on what your goals and your objectives are. By hiring somebody as opposed to a family member, the main difference is when you hire somebody, you have to pay them to serve in that capacity, whereas usually family members are willing to serve for free when you nominate them as your financial or your personal representative.
Oh, okay.
Yes.
Kind of related to that, for somebody like me who's been a family member who has been a power of attorney and personal representative, is there any pathway to become like a professional contracted PR?
The question.
Is it better for them to just go with like the fiduciary company or specials?
So the question is if you've previously served in a capacity as a fiduciary, personally, if you can be a professional. There are certain educational and financial requirements to get licensed and bonded to be a professional fiduciary. There are courts that do hire and certify personal fiduciaries for certain matters. If you're going to be a fiduciary and you're a privately paid certified fiduciary, I would just recommend having a conversation with the individual that's nominated you to set the proper expectations, because are they nominating you because you're a family member and they're nominating you in your personal capacity, or are they nominating you in your fiduciary capacity, in which you'll have to report it on your insurance, your licensing, your bonding, and all of that. And potentially, does that cause a conflict of interest in your professional field and your private field with that individual that you may be serving for? Yes.
My brother was appointed as power of attorney when my mom died, and there are things that are unresolved. Does the power of attorney expire, or is it revocable? There are things that my brother has not completed, and I've asked him for reports and he doesn't get it done. And but I don't know how to have any leverage to change what's going on.
So the question is the power of attorney revocable upon a certain event, or can you change it or have information relayed to you as a beneficiary? Is your mother still alive? No. So a power of attorney is a document that gives an agent the ability to act on behalf of a principal during their lifetime. If your brother only has a power of attorney for your mom, that power of attorney is no longer valid after death. It would depend on if your mom also had other estate planning documents, including a will or another document that nominated him as the personal representative. And depending on what capacity he was serving in, whether she had a will and he's the personal representative, or if she had a trust and he's the trustee, there are certain rights as a beneficiary you're entitled to, but depending on the type of document that was enacted is going to determine what your recourse action is. But if you want, my contact information is in the back. If you wanted to call my office, we can talk about that more privately in detail.
Yeah, and it's also complicated because it's international, because my mom lived overseas.
Mm-hmm.
And so there were complications from what happened in that state. But yes, I would like to.
Mm-hmm. Yep, please go ahead and contact my office. We can discuss it more in detail.
Okay, thank you.
You're very welcome. Any other questions? Okay. Well, thank you everyone for joining us. I appreciate it.